everyone, and it's been really fun hearing about zombie properties. I think that's very cool, and Syracuse has done quite a bit with that as well, so I may share a little bit about our rental registry as we go through this. But just briefly, I think everybody after that, maybe take a deep breath and maybe stand up, shake off a little bit, because, you know, a bunch of lawyers talking at you for a while can be a little draining. I get it. My kids tell me that all the time. So let's talk about landlord-tenant law in general, and I'm going to talk probably about 35 minutes or so, and then we will get into your questions and answers, Q&A. So this is me. Why am I talking to you? I'm with the Volunteer Lawyers Project of Onondaga County. We'll be able to share all this information afterwards. You'll be able to reach me if you have questions. Why me? Our program basically represents tenants. So why do you want to hear what I have to say? That's probably a good question. But and I'm not in Auburn. We have a presence in Auburn where we help people who are experiencing homelessness or have other like employment barriers, or who have questions about landlord-tenant issues. We have a presence there, but we don't represent tenants in Auburn. And so that's partially why, because I am coming from the outside of the area and can provide a perspective and let people know what's happening statewide, kind of what the trends are, and you know, and I don't represent landlords. So we'll do a basic introduction, talk about the rental cycle, tenant rights, landlord's rights and responsibilities of both parties, the Housing Security and Tenant Protection Act of 2019. Now, if we were in person, I'd be like, how many people are aware of this act? And at this point, I think most of you should be aware of it, but may not know all the details. So we'll get into a little bit about that, how evictions happen, why they happen, and what's happening with COVID. Because seriously, every single week there's been a change in the law. This whole summer has been incredibly stressful and challenging for everyone, and I get it. It's been hard on landlords too. So we'll talk about that, okay? Where things stand today, as opposed to yesterday or last week or next week, and a little bit of Q&A. So first, lawyers need to do this, right? No attorney-client relationship is created. We are providing general information about the law. We are not going to necessarily get into your specific situations. You would have to seek an attorney for that. We don't represent landlords. So I can provide general information about the law, but this is not creating an attorney-client relationship. Our mission of our organization is to provide access to justice through engaging the volunteer community, the legal community, in volunteer service. So we have volunteer attorneys, about 600 on our panel, who provide help to people experiencing poverty in our communities on a variety of issues, not criminal law. So like law is divided into criminal and civil. Civil law can sometimes be anything but civil, right? But it's all those things that really affect people in their basic everyday lives, like family law, their housing, their names, even getting name changes done, elder law, surrogates court, all kinds of things like that that are not criminal defense. We don't do that. We do the civil law, and we engage volunteers to do that. So even though we have a really small staff, I think there are 9 of us now, by leveraging the power of all the volunteer attorneys throughout the area, we're able to help people. And our tenant eviction defense program in the city of Syracuse and village of East Syracuse represents between 800 and 1,000 tenants a year. We basically stand at the courthouse door, and virtually, we appear virtually now that we're in court. And we'll talk about that, like what are the courts doing now? And we help to negotiate, we help people to communicate better, we help to improve the relationships and to come up with solutions that will hopefully help people avoid or delay eviction, reduce judgments due, and for all parties to better understand their rights and responsibilities to each other. We have a history in Syracuse, I'm sure in Auburn as well, of redlining and racial and economic inequality. So this was set back decades ago, and we're still seeing the effects today. And I took out the wrong slide, because there's supposed to be a slide that shows this side by side. And side by side, we would show the redlining. This was done back in the 30s to the 60s, and this was a federal policy of dividing up cities by what they consider to be calculated risk, and that generally followed in the lines of, well, the African American communities in our cities were deemed to be more risky. They were the red areas and then the yellow areas, and the side-by-side map, which I took the wrong one out, would have shown clearly that even though this happened decades ago, today those effects are still continuing, and the cases that we see in the city of Syracuse almost mirror these lines directly. So we're seeing these effects. Eviction is a massive societal problem, and when we're caught in a small, like, one-on-one situation with maybe one renter who's having difficulties, then it's hard to see. But overall in our communities across the country, there are 2 to 3 million evictions every year. And if you've read the book Evicted by Matthew Desmond, you know that the studies have shown that, yes, eviction can sometimes be a result of poverty, but it also causes poverty and causes people to lose possessions, to fall back. It's very rare that someone is evicted and ends up in a better situation than they were before. And that creates a drain on our society, on our systems, on our communities, on our tax funds, on all of the resources that we have when people need extra help. So maintaining housing stability helps people to maintain their treatment programs better if they are ill. It helps people to stay in school. It helps children to be better educated and have more opportunities. At any one time in the Syracuse City School District, 10% of our children are experiencing homelessness, and that's huge. 10% of every classroom. And those children have a rougher time, you might imagine, getting their homework done, focusing on their advancement. So briefly, the housing, well, actually, this may not be too brief. I've got a lot of slides on this one, actually, because it's important. There were many, many changes that came about. Landlord-tenant law was the same for decades, and all of a sudden in 2019, things changed like literally overnight. This act came on June 14th, and all of a sudden we were in court the next week, and nobody could stay in court because they hadn't met the prerequisites for being there. It was a crazy, crazy time. What changed? Just about everything. So I'm going to briefly go through this. And and hang on to your questions. You can put them into the Q&A or into the chat, and we'll address anything specific, as far as the laws go as we go forward. So what I advise everyone is to think of renting, the rentaling, as a cycle. So we start with the end in mind. So when you're starting a rental relationship, you have to understand that the property will almost always go back to the landlord. It is a cycle, and it will always end. So it makes sense to start it by thinking about how it might end. Be clear about it. Before someone moves in, you want to make sure that you're very clear on everything. Like, what are the terms? Is this a month-to-month? Is this a full year lease? Is it 6 months? Who is signing? Who's going to be held responsible if the rent can't be paid or if there are issues? I mean, simple things like, who's responsible for shoveling? That's kind of important in Central New York, right? Where can you park? Getting as much in writing as possible is good for both parties. It's good for everyone to just have a clear understanding. Understanding joint and several liability is really important. Now, what is that? Joint and several liability is when two separate people sign the lease, they can each individually be held responsible for the entire amount of the rent. And a lot of times tenants don't understand that. So if you're having tenants sign a lease, you want to maybe take that extra step and explain to them what that means. Because if you've got a $700 a month lease and you've got two people who are friends who are signing up to be roommates, they may think that they're each only individual for $350 of that. But with joint and several liability being the law, they are each responsible for the whole amount. If they have to know that they trust each other. You have to know as a landlord to protect yourself that they're going to be responsible for the full amount. And that if one of them doesn't pay their share, the other one could face eviction for the balance, right? So that's really important to be clear up front. Are there any fees? What are the security deposits? How will the lease end? What are the notice requirements from both parties? You can put those into writing, and generally speaking, lease terms that don't violate the law will be upheld because it's considered to be a contract. Unless it has like really fine print and things are sneaky or they're violating clearly established law. So, draft your leases carefully, okay? Before people move in, I put in purple here the changes from the 2019 Act. There is now a limit to application fees. It used to be people would charge whatever, but now it's limited to $20 maximum for the cost of a criminal or background credit check. That's the only application fee that's now allowed. And at move-in, we used to see a lot of first month, last month, and security deposit due up front, and that has changed statewide. Now only 1 month's worth of rent may be charged as a security deposit, so that's a thing. I also recommend for all parties, do a walkthrough before they take possession. Before you hand over the keys to a tenant, do a walkthrough. I advise tenants, landlords even too, to take pictures, but even have a checklist, like get a signed agreement. If there are damages at the time that the possession is given over, then you can't charge the tenant for those damages later on. And I think it's important that everyone be clear on what the condition of the property is at the time that it's transferred. That's just for everyone's well-being in the future, right? What must a landlord provide? So by state law, a safe, habitable, sanitary place to live, right? You can't put people in zombie properties that are not safe. And it's really important that everyone understand the warranty of habitability is implied in every contract. It must be free of vermin and insects infestations. The right of quiet enjoyment doesn't necessarily mean that they have a right to like a perfectly quiet property, but it means is that they are free from intrusion. It means that there are locks, there is privacy. A landlord or a maintenance person is not going to show up in their living room, unannounced while people are in the shower. That's just not appropriate behavior, and it's violating state law, actually. So, and the two words that keep lawyers in business are "it depends," right? So every situation is evaluated differently and based on its specific facts, but locks and privacy are kind of key. Working electrical, working plumbing, working heating and ventilation systems. Now, there actually isn't a law that appliances be provided. People can bring their own, but if they are provided, then they have to be working and kept in working and safe condition. Carbon monoxide and smoke detectors are required. Disclosure of any known hazards. So one of the questions I got was, what must a landlord provide to someone when they're renting? And that question is, you have to provide the lead notices. There are federal lead notices. If it's a known hazard, you have to provide them. And it's in your best interest to do it in writing, right? So you can show that you've done it and prove it. Of any known hazards, a copy of the lease. It's really, people who sign documents have a right to a copy of that document. You can't just like, here, you signed it, and then I'm going to go take it away and not let you see it. So that's really important. And throughout the tenancy, proper notices and due process as required by law. A warranty of habitability is implied with every rental. And we're in difficult times. They're difficult for everyone. Tenants still have a right to safe and habitable housing, even if they are unable to pay the rent. And I know there are going to be a lot of questions about the COVID moratoriums and the money. We'll get into that in detail. But even if people can't pay the rent, they still have a right to safe and habitable housing. And I'm thrilled to see that the codes department in Auburn, was presenting before me, and that they are, looking into these issues, and that they will be investigating properties. It is also illegal to retaliate against someone for contacting codes or complaining about property conditions, and it is presumed by law, unless you can prove otherwise, that if a landlord takes an action against a tenant within a year after they've made a valid, good faith complaint, that it's in retaliation. So if all of a sudden, like I had a call yesterday from a tenant who had finally called codes because nothing was being done about an unsafe condition, and 2 hours later gets a notice of lease termination. That's kind of like the blanket definition of retaliation, and I would advise against it because it would invalidate that action, right? The courts aren't going to uphold it. Briefly, landlords also may not discriminate. So you can't treat people differently because of, all the common factors we all know, right? Race, color, religion, national origin, age, marital status, military status, disability, sex, gender, sexual preference, identity, and having children. You can't discriminate against people because they have children or because they're going to have more children. And also, in April of 2019, the new statewide source of income law came about, and that means that landlords may not discriminate against someone based on where their rental payments are coming from. So if they're getting Section 8, that's fine. You have to accommodate that. And I know there are landlords who just don't want to deal with the paperwork or don't want to mess with it, but by law, it's required. And if you have questions about that, I've put the number for CNY Fair Housing here as well. Service animals and emotional support animals. We get a lot of questions from everyone about this. If you're confused about it, I'm trying to make it as simple. I put this in black and white, all right, as simple as possible. They must be allowed when proper documentation is provided. Well, what kind of documentation can you require? Documentation of a medical necessity for the animal for a specific condition, physical or emotional, that someone is experiencing. Landlord, however, may not ask about the specifics of that condition. So you can request a document from a doctor that says that it's required for a specific condition, but you can't know what that condition is, okay? Landlords may not charge pet fees for service animals, and they may require, and then I think in fact should require, reasonable standards of care for that animal. So if the animal is not being treated well, if you're in an apartment building and there's a horrible smell because they are not taking it out to walk and they are not taking care of the animal, it's appropriate for a landlord to step in there, just for the safety of and the living conditions that other tenants are experiencing as well. So you may require reasonable standards of care, treatment of the animal, maintenance of sanitary and safe conditions. And if you have any questions about that, go ahead and put them in the Q&A or the chat and we'll go into it further. But this is as black and white as I could put it, okay? My father is a Rochester fire chief, or was a Rochester fire chief for almost 40 years. So I put this in all my presentations. Working smoke alarms save lives. So it's not enough to have a smoke alarm. It actually has to be working, and I'm the one who will burn dinner and, pull the battery out because I don't want it smoking. I don't want it making noise in my kitchen. But you've got to have their smoking alarms working and the batteries working. I remember one of these presentations, I think it was a couple of years ago, there was a program to help landlords get working smoke detectors. I don't know if that's still part of what's happening today because I haven't seen the agenda, but put them in, make sure they're there. It's not only a law, it'll save lives, and make sure that they're working. And here's how many there have to be. So one smoke alarm on every floor and sleeping room. And in every bedroom. Another new part of the Housing Security and Tenant Protection Act made it more of a law, like even more than it was before, a requirement that landlords give receipts with payments and keep 3 years worth of records. What this means is that it's the landlord's burden to prove non-payment. So have your ledgers, have your paperwork. Don't just scribble things off on a napkin and say, I received $400 from Joe Schmo. You need to keep records. They want that in order to prove what you may need to prove down the road. And I know there are a lot of people who pay with cash or money orders, and we say, those aren't, a money order is not a good enough receipt. You can prove where you bought it, you can prove you bought it, but you can't prove where it went. It's just like cash almost. And by the time you'd be able to prove anything, the court would be over anyway. So we tell tenants, if you're going to use money orders or pay in cash, get a receipt. If they are paying by check, you don't by law have to give a receipt because a canceled check is the receipt, unless they ask for it. So if they ask for it one time, that one ask is considered to be enough for the rest of the tenancy and to require a receipt every time, even if they're paying by check. So another thing that most people don't understand, or a lot of landlords seem to be really surprised by this actually, and that's what I put in here, is the roommate law. and this is statewide. Any lease or rental agreement shall be construed by law to permit occupancy by the tenant, the immediate family, one additional occupant, and dependent children of that occupant. And that's for each person who signs it. So provided that it's used as the tenant's primary residence, they are allowed to have guests stay. They do have to notify the landlord if asked of who's living there. You have a right to know who's there, but they do have a right to have people stay with them even if they're not on the lease. And at the end of the rental cycle, proper notices of termination must be given. So you look to the law, you look to the leases to see what's required. The law changed, and I'll get into more detail about this, but the law changed last year, and that a tenant has the right to give 30 days notice no matter how long they've been there. A landlord, however, who is looking to terminate the lease, whether it's month to month or a regular lease, or if they're looking to raise the rent by more than 5%, have to give notice based on how long someone has been there. So if someone has lived there for less than a year, it's 30 days notice. If it's more than a year and less than 2 years, it's 60 days notice. And if it's over 2 years, they have a right to 90 days notice of such a major change in that rental relationship. So be aware of that, and it now must be in writing, okay? At the end of a rental cycle, once those notices are all made, a landlord now must offer the tenants an opportunity to have a walkthrough 14 days before they're scheduled to vacate, at which point the landlord's supposed to give them a list of anything that they need to fix or change or that they would charge them for against their security deposit, and the opportunity to make those changes before they leave so that they could avoid the charges. So that's in the law now. Also in the law statewide, it used to be that a security deposit just had to be returned within a reasonable time, whatever that is. Now it's 14 days, within 14 days of vacating. And if a landlord does not return the security deposit or give the list of reasons, or deductions within 14 days, the law determined that they have forfeited their right to that deposit. And then the tenant can get it back through judgment or small claims if the landlord's not returning it appropriately. So how do evictions happen? Most of you landlords, you may have gone through this, but you probably know that most tenancies don't end up in court, right? Most rental arrangements go through their cycle, they end, people leave when they're supposed to, or they make arrangements and they work it out, and it just ends because it's supposed to. Evictions happen in New York State one of two ways. There are two basic types. One is called a holdover. That's when someone was given notice to leave, or there are claimed lease violations or misbehaviors, and the landlord said, enough, I'm ending your lease. And they give the proper notices. Or non-payment. And non-payment in the city of Syracuse is about 85–90% of all cases. Both require due process. So non-payment is like repossession of the apartment. Now, why I think it's really important is that a lot of people don't really realize that there are two separate types of cases. They can't be claimed at the same time because they are saying different things. A holdover case is telling the court, hey, this tenancy's ended and I want my place back. The non-payment is saying, well, we have a rental arrangement and they're not meeting their obligation to pay, so I want the place back, but it's still a continuing obligation. So in non-payment, you'd be seeking rent payments. In a holdover, you'd be seeking the value of use and occupancy, which can be determined to be rent or the same as rent, or something similar depending on what the court determines, because it's not enforcing the rental agreement, it's saying it's over, and they're different, and so they can't be done at the same time. And a lot of people don't understand this. Another reason why it's important to understand that there are two types of cases is because of the new laws and the eviction moratoriums and processes that we're experiencing now during COVID. Most of them have to do with non-payment. But they also look at like what's appropriate for holdover during a pandemic, and we believe that we may see more holdover type cases where the landlords are like, fine, you're not going to pay me, I get that, you've got whatever defense is, I'm just going to terminate the lease and give a holdover notice and try to do it that way. But I think you will find that legal service agencies know that that's the next fallback strategically and will be fighting any holdover if the basis for it is the non-payment, because it goes against the whole intent of what we're experiencing right now. Notices before summary proceedings, and these were all changed by the Housing Security and Tenant Protection Act. In a non-payment proceeding, the demand for rent must now be written 14-day notice. Used to be you could give a 3-day notice. Now it's 14 days. You also must send a certified letter if the rent has not been received by the 5th day saying, hey, we haven't gotten the rent. And some attorneys will advise that you combine those. I don't give landlords advice on that. That's something you want to chat, with your attorneys about if you have them. Like, how do you give the proper notices? The 5-day notice is basically, I think, to cover a situation where sometimes people will put a money order in a Dropbox or they'll mail it off and you haven't gotten it by day 6 of the month and it's late. That notice is to give them notice that you haven't gotten it. And if you don't do that certified letter, it's an affirmative defense to the case, because the tenant can say, I didn't know that you hadn't gotten the rent. And it's supposed to give them more time to kind of come up with it as well. So the 14-day notice is important, and it must be served properly. It can't be served by a party to the action, so the landlord themselves can't do it. You want to have any other person over the age of 18 to do service for you, and service of notices not done appropriately is a way to have the case disappear from court, because it destroys the court's jurisdiction. The court can only make a decision if they have jurisdiction over a case, and they don't have jurisdiction if they haven't been given the proper service of process and notice. So service of the notice and petition, not at least 10 and not more than 17 days before a hearing, and they may be able to answer orally. All parties have a right to request an adjournment of 14 days of court. A warrant, once issued, the court will issue the warrant once they've gone through the court process, and that also gives 14 days notice now. And what's changed, made official now, is that at any point up until they come to do the lockout, this can be cured. If it's a non-payment case, the tenant can cure it by paying the amount of the judgment, paying what was sought in rent. So that's really important to know. And they've also clarified that now warrants can only be executed between sunrise and sunset on business days, not on weekends, not on holidays. And if you are bringing cases to court, the warrant is only effective against the people who were brought to court. So you have to be super careful about who's named in the petition. Like, if they've got someone living with them, you want to make sure they're named too. The issuance of the warrant no longer terminates the relationship, like I just said, because they still have the opportunity to pay if it's and this is for non-payment cases. And at any point, they have the right to pay to rescue the relationship or rescue the rental. Stay of warrant, and this was kind of on the last slide as well. There is a new law now that the courts may grant discretionary stays for non-payment and holdover proceedings if there is extreme hardship and the tenant has asked in good faith and they're able to pay the rent going forward. So they have a right to request for up to a year that they be allowed to stay as long as they're able to pay going forward. And there are factors to be considered, but this is where it comes from. Also, if the landlord's claiming a breach of lease, the court is supposed to grant 30 days for the tenant to fix whatever that claimed lease violation is and give them an opportunity to cure before they would issue a warrant. So graphically, I have a great intern last summer who created this for me because it's important to see things changed a lot in 2019. We have our old laws from the day of the 3-day demand to the eviction. It could have been an 11-day turnover for possession of the property. And now with the 14-day demand, the file and serve for court, you have your court, then you get a 14-day warrant. If there's an adjournment, it could be up to 52 days before possession's turned back to the landlord. And without that, it would be 38 days. So it's a huge change. And if this is new to you, now you know, okay? And this is what I'd mentioned before. With the holdover cases, landlords may not increase the rent by more than 5% or terminate a lease without the proper notice, and the notice times change. And this was just in October. So as of October 12th, the written notices now, it can't just be a phone call or a, hey, you know, I'm giving you 30 days to get out. It's got to be in writing, and it's based on length of occupancy, so how long someone's been there. We call it the 30, 60, 90-day rule. And this is before you can bring a holdover case. So if the landlord's planning to terminate the tenancy, this time period has to expire before they can even go to start filing the case at court. So I like cartoons. I think this one's a little cute. All right. Take a deep breath now. Let's talk about the COVID-19 moratoriums, okay? I know this is a lot of material, but this dude is kicking the can down the road, and that's what we've been going through all summer with various moratoriums and processes, and we just keep pushing it down the road because this is such a massive problem that's potentially heading our way. And I believe that landlords kind of got stuck in the middle here, frankly, because you can't evict someone, you can't get your property back, and at the same time people are not able to pay, and this is creating problems, and it's well recognized. The question is what's going to happen and what are we all going to do about it, right? So the first thing that we saw federally was this CARES Act, right? The CARES Act, most of it expired in July. It was a prohibition on non-payment evictions for properties that were owned or mortgaged through federal funded programs. So if you had some kind of a federal mortgage, it was a 120-day prohibition, but that expired back in July. It has not been renewed. That hasn't been an issue, and at the time no late fees or penalties could be charged, and they still owed back rent after the fact. So when the stimulus package died, everything messed up, and that's when we saw the CDC Act come into effect federally. But before we get to that, there is a portion of the CARES Act that can still be in effect, and that's when properties with federally backed multifamily mortgage loans have accepted forbearance on their mortgage, meaning that they're not paying because they're not getting paid, and there's an opportunity for them to not have to pay or to have that mortgage held off for a while as part of the condition for that. And receiving that forbearance, they've agreed not to evict tenants. And so that they have to give 30-day notices when the time comes. They're not allowed to charge late fees or penalties. I don't know how many properties this might apply to. The CARES Act in general applied to about a quarter of all rental properties in the country, but 4023 still technically could be in effect. The problem with moratoriums is you may have experienced this with some of your tenants. A lot of people misunderstood and thought, oh, this means I don't have to pay the rent. And rent has not been waived, right? It hasn't. This is particularly concerning for those of us who deal a lot with people with disabilities, people on SSI or SSDI who have a steady stream of income and may completely have misunderstood this whole process. So they didn't have financial hardship necessarily due to COVID, but thought that this moratorium meant that they didn't have to pay the rent. And everything and also there's a lot of confusion, there's a lot of advocacy, there's a lot of rent strikes and calls to waive the rent around the country. Advocates are fighting for that for tenants, and at the same time it hasn't happened, and rent has continued, and the rent obligations are continuing. So nationally, we're expecting an eviction tsunami, really. So rent has not been waived. We've got another wave coming, and this wave is going to be potentially huge. The numbers that we've seen, and why we've got some kind of, stopgap, kick the can down the road measures are because of this tsunami coming. They're expecting anywhere between 17 and 24 million households to be evicted when these moratoriums end, if they don't end properly, if we don't get some funding for landlords, if we don't get some help here. The CDC order was a temporary halt on evictions. For tenants experiencing financial hardship, they must make best efforts to seek payment and seek assistance. It goes through the end of the year. Tenants must present a signed form to the landlord that's made under penalty of perjury, and the rent is still due. Again, it's not being waived. The rent obligations are still due, and so we're hoping something new is going to come down the pike and that we'll get some more funding. And some evictions are still expressly allowed, like the holdover cases I talked about, when there is some kind of risk to other tenants or other issues. New York, I just thought this was a pretty picture, and we need some calming influence in our lives, right? So the Tenant Safe Harbor Act in New York, what does it say? It says no warrants for eviction for non-payment during the COVID-19 covered period against a tenant or any other lawful occupant that has suffered a financial hardship during COVID. So the tenant has to actually present this in court as a defense. There's no document to give like the CDC or anything. A landlord still can get a judgment for rent that's due, but they can't evict based on that judgment, because normally a non-payment eviction is based on non-payment, and if you get the judgment and they can't pay it, you evict. Now it's saying you can get the judgment, you can try to seek payment on that judgment, and by whatever means you would do, but you can't evict based on that. And the recent executive order from this past month extended this through, so the COVID-19 covered period was for, it covered the time period where there was any restriction on public gatherings of any number in the county where the property was. It's a little unwieldy. So it's been extended through December 31st for now. And it also includes those warrants that were maybe issued in February or March before COVID hit, but have not been executed on yet because there was the moratorium. This is extending it, but it's not a full stop. It's not all cases. It's for non-payment cases. There is currently a moratorium on utility terminations. They may not discontinue services during this state of emergency. There was an Emergency Rent Relief Act that had $100 million of federally allocated money for rental subsidies throughout the state. That was through April to July, and the application period for that is ended. So unfortunately, that Rent Relief Act has expired and is no longer available through the state. The New York Forward Loan Fund, from what I can see, is still a possibility for small landlords to look at, and you'll get these materials sent to you, but this is also available online. You can just look up New York Forward Loan Fund. It's administered through large banks, and it is basically a loan. It is not a forgiven loan. It's a loan that has to be paid back, I think, within 5 years, and for landlords who have less than 200 units and for buildings that are less than 50. So it's a possibility that that might be something for landlords, and I put the website on there and you'll get that as well. And it has to, again, be in good physical condition. The property has to be habitable. So we have a mishmash, and the law right now is crazy because we have the federal laws, federal orders, state executive orders that are coming down from Governor Cuomo's office pretty much monthly, sometimes even every other week, changing things. We have the courts have their own administrative orders, both at the upper level of all state courts, we see from Judge Marks, and then from the local courts. So where the heck does that leave us? Like, where are we right now? And it's a little different, I think, in Syracuse than it might be in Auburn, but let's look at it. So right now, as of right now, the courts are hearing matters that were filed before COVID started, and they are able to schedule them, but because of the executive orders and administrative orders, they cannot issue default judgments against tenants who can't show or don't make an appearance. So there are no default judgments, no default evictions. That goes through at least November 3rd. It could be extended. He's been extending things by order about a month at a time, and we usually find out at like midnight the night before. Syracuse City Courts have started scheduling new cases. And the newest administrative order says that new cases may be scheduled. They just can't have defaults. So most courts are not scheduling them yet. because what's the point? They can't issue much, and they can't do much potentially. So Syracuse is starting to schedule their new cases as of November 9th. We've gotten notice. I'm not sure what's going to be happening in Auburn, but I do believe there is a pretty strong rumor out there that within the counties of Cuyahoga County and some of the areas, that they're going to be doing what's called consolidating the courts. So this is just a rumor, don't take it. I can't guarantee it. I haven't seen anything in writing, but I have heard that within this county, they are looking to instead of having the courts or the cases be heard by like all the village and local town justices, that they're going to consolidate landlord tenant court into possibly one or two larger courts where the judges are attorneys for sure and understand all the new laws and defenses. So that's what we think may be happening. And the state courts have said that all proceedings going forward should be remote whenever possible. Warrants may issue, so that they can actually issue warrants of eviction. However, they may not allow eviction if there are COVID-related financial hardship defenses through the CDC Act, the Tenant Safe Harbor Act. It may extend to some of these holdover cases, and basically the courts have said it may be up to the court to decide. So landlords who are frustrated by lack of these formal processes, we're seeing frustration all over. I would caution landlords to be careful. The Tenant Safe Harbor Act says they can't be evicted for non-payment for financial hardship. However, if it comes pretty clearly that those notices are given because of the non-payment, even if it's disguised as a holdover, I think that might not be allowed by some courts. And also, I think it's super important that landlords be aware of what is against the law when it comes to self-help eviction. So if you're being deprived of a court process, can be incredibly frustrating, right? But self-help under RPAPL 768, any person can be found guilty of violating these provisions. So it's not just the landlord, it could be the property maintenance person, it could be a property manager, it could be any person. And these protections apply to anyone who has lived on the property for over 30 days or who has a signed lease. And the penalties are pretty steep, up to a year in jail. It is a criminal Class A misdemeanor of $1,000 to $10,000 in worth of fines for every act, and additional daily fines for noncompliance. The Attorney General's office has put out a really good guidance to law enforcement agencies. So the law enforcement, police, sheriff's departments, state police, they are supposed to know that tenants have the right to stay in their property and the landlord cannot take self-help eviction act. Well, what are self-help eviction actions? What are we talking about? These are things such as threatening the use of force, calling repeatedly, yelling at them, telling them, just get out, banging on the doors, interrupting services like heat, hot water, electric, removing their possessions is a pretty clear one. Removing the door, we've seen that. We've seen people trying to change the locks without providing a new key, plugging the door locks, making them inoperable, failing to take all reasonable and necessary action to restore occupancy, or any other action which is intended to prevent lawful occupancy, interfere with the use, or induce the occupant to vacate. So those are now a crime. That's a lot to swallow, I know, but taking self-help is not the right way to go if you want to avoid this, and it's for pretty much any rental situation. Okay, so deep breath, that was a lot. Thank you for your patience in hearing me out. And now I am going to stop sharing my screen and take any questions that anyone might have.
All right, excellent. Thank you, Lori, very much. So I've got a couple that have been popping up in our chat box here. So I'll read them off to you since we're in a webinar view. And then anything that you feel that you can't answer, that's fine. You can just defer it for later. Also, I see this one's just for me, but every landlord's legal guide that we hand out with this training, we'll be reviewing how to get that at the end of this during our wrap up. So I just want to let people know because there are a couple of questions in the chat about that. So the first one that came through is, does the landlord have the right when a lease is being re-signed by the current tenant to go in and do an inspection?
Yeah, I mean, an owner has the right to do an inspection with proper notice for safety reasons at any time, right? But you have to, you give 24 hours notice, make it during a reasonable time during work days. You have a right to go in and inspect, yeah.
Excellent. So another one that just popped up, landlord? I just want to pre-read them to make sure that they're not like too specific. What can a landlord do if a tenant does not give access to fix a property and is not allowing the home inspector to come in? Like it seems like a tenant is denying the landlord access, is there?
Notice a landlord should have the opportunity, I mean, should actually have a set of keys, frankly. Like, tenants have a right to quiet enjoyment and to be free from unreasonable intrusion. But if, say, there was an emergency, say the water line broke or there was a fire or the property owner should have the right to get into the property in the case of an emergency or in the case of needing essential repairs with proper notices, which I would document if you're going to give notice, even if it's by text, just have something in writing, not just a phone call.
All right. So the next one we've got, and like I said, that one was a little bit maybe more specific because they also are mentioning that the person's is a little bit behind on rent. So, but that was a good overview for it. And like I said, I'll try to keep these general. And then we just advise that if anyone does have specific questions, reach out to your own, individual contacts. So the next one is, can a pet fee be charged for emotional support animals, even though we cannot charge one for service animals?
Nope. An emotional support animal is a service animal.
Gotcha. Excellent. All right.
Not a pet. They are tools. They're medical tools, essentially.
Excellent. All right. So a couple more we've got coming through here. And I will try to get to everyone's.
Oh, you know what?
I knew there'd be a lot.
If you want to gather them, I could briefly touch on something that I forgot that I was going to mention.
Yeah, sure.
Is the rental registry, because I know they were talking about that as a possibility for Auburn. And Syracuse has one and has had one for several years now. And we've gone like ups and downs as to how it's enforced and what it means. But statewide also, last year, there was another law that I forgot to put into my slides. It's the Multiple Residency Law 302A. And what that law says is that if there is a property that has 3 or more units and it does not have a current certificate of occupancy or certificate of compliance with codes laws, then the landlord may not lawfully collect rent or evict for non-payment of rent. So that's huge. And I cannot believe that I forgot to put it in there, right? And so that's really important, because what Syracuse is doing as of November 15th is they are tying, the rental registry was for 1 and 2 family homes and non-owner occupied, and they're going to tie their rental registry to that. We use the same language, basically saying that if they are not part of the rental registry and have not met their code's compliance rules, then they cannot collect rent or evict for non-payment of rent. So they're changing it to give that rental registry more teeth, and it's something I've been advocating for a couple of years now, and I think will really help to reduce blight in the area and will help people keep their properties and make sure that our tenants have safe homes. I mean, and my father's a fire chief, right? So I really want to know that if there's a fire in a property and the fire, that they're going to be safe too, like that the conditions are okay. And so that's important to me.
Excellent. All right, so we've got a couple more coming through here. And I know there have been a lot of talk about the COVID laws and things like that, and I don't know if this one's too specific or not, but how does those COVID memorandums affect people whose income has not been affected by COVID? Are they in the same position where they are also not having to pay rent, or they can defer those payments? How does that work if your employment has not been affected by COVID?
This is where there's a major misunderstanding of the law, and it's been like my biggest fear all summer. No, rent has not been waived. Rental obligations are not waived. There is no moratorium any longer for people who haven't paid the rent. And if they can't show that the non-payment was because of a financial hardship, and there are 4 factors that the court's supposed to look at, including, like and I don't have them off the top of my head, but that they have to show the court that their income before COVID, their income during COVID, whether they received any benefits, to see whether or not they were able to pay the rent. And so if it wasn't related, this is an affirmative defense, meaning they can stop an eviction if they can prove the financial. Without that, it could be really difficult. And the courts are going to start hearing these cases very soon.
Excellent. All right. And then another one, a little bit more general, but do you have any recommendations if you have a family member as a tenant? Any additional precautions or steps you should take? I'm assuming you would need all of kind of the same documentation, that they would be treated as a normal one, but any advice for family members as tenants? Any specific things you recommend?
Yeah, take a look at that relationship and say, like, how close a family member is it? Because if there is an implied obligation to care for that person because of the family relationship, then that person might have more rights, and it might be harder, say, to evict in the long run if they need to, or if they're not paying or not taking care of things. So that's one thing, because sometimes those family relationship cases don't go to regular landlord-tenant court. They would end up in Supreme Court. Also, as with any other tenant, if you can formalize things, get understandings in writing, then it solves. You can always change it, right? But if you've got an agreement in writing, and everybody's clear on what it is, then it can help in the long run to smooth over any difficulties or challenges.
Excellent. And I know we're circling back a little bit here to support animals, but a couple more have come in.
Okay.
Are landlords allowed to not allow non-traditional support animals, such as like snakes, pigs? Is there any guidance on non-traditional support animals, I guess, if you're aware?
That is a really good question, because my understanding is that there are more and more limitations that are being considered, but that they're not in place yet. And I would assume that when you're in maybe I'm making a bad assumption, but I like in a more rural area, you might have more, I don't know, emotional support pigs or peacocks or whatever they are, or snakes, rats, but if that particular animal is providing the emotional support that someone needs, and they're maintaining that animal, in a secure way, and it's safe, then my understanding is that it needs to be allowed. But you have a right to require documentation.
Excellent.
I know it's awful. It's like snakes on a plane. I get it. But at the same time, people have a right to the support that they need for their mental and physical well-being too.
Yeah.
So, and if you have questions about like a specific situation, reach out, talk to your lawyers, talk to the CMY Fair Housing has more information about that. We don't get a lot of it because we focus on eviction defense. We're in my office, so I don't deal with it day in and day out the way some other agencies would.
Awesome. And then it looks like we're down to our final 3 questions here. They've trying to stop trickling in, but this one, and I might have to, if the person who asked this, if I'm asking it wrong, just jump in the chat and let me know. Are laws any different for owner occupied in regards to income rules where landlords have to accept Section 8 or home site? So if you're owner occupied, are you still required to accept Section 8 and home site forms of payment? And that might be a case specific one too that they would have to look into. But
right, and with the source of income law, that's pretty blanket, and there doesn't seem to be any exclusion from that. But I can't guarantee for sure. I don't believe that there's any exception, but it'd be worth looking into if it was your situation and you had concerns about it.
Excellent.
I can't guarantee it. I don't, off the top of my head, I don't believe so.
Gotcha.
But hey, it's always worth a look.
And then this one we've got here, when it comes to seeking the judgment for rent owed, since they're not seeking the eviction, will the delivered notices to the tenant be considered in court without the notice being in certified mail? So like a monthly notice. I guess it seems like they're asking, so if you're not looking for an eviction where you need all those official, forms of delivery and you're doing it via certified mail, if you're just looking for rent owed, does that follow a similar pattern where you have to be very specific about how you're giving those notices, or is it a little bit more general?
It would see, this is the problem. We don't know exactly how this is all going to play out, frankly, because how the courts will hear them. But if it's like, because in Syracuse, we have a dedicated court for landlord tenant. There are like 5,000 cases a year. And so it's all landlord tenant court, and it doesn't belong under the RPAPL, which is like, you've heard that before, but that's like the proceedings law for possession. And it doesn't belong in that court if they're not seeking possession. So we probably won't even hear those judgment type cases. It'll go to Supreme Court or small claims court, depending on how much. The notices will not be required the same. The required notices are not the same when you're seeking a judgment. So to answer that simply, I guess, no, you won't have to have the same notices if you're not seeking possession. However, not having given those notices is not helpful to you, right? You want to have the proof that it's actually owed to you. You want to be able to, support what you're saying to the court, and following the processes and procedures helps.
Right.
Improving your case.
Gotcha. All right, so it looks like nothing else has been coming through on our question lines. We'll give it just another couple of seconds while we wrap up here if anything pops up. However, we are gonna have your contact info. So if they need to reach out to Volunteer Lawyer Project or they're interested in your organization, we can direct them to that site. It looks like the lines are staying quiet. So Lori, we appreciate you coming and speaking here, and thank you for taking us through all of our questions. And we're going to wrap it up.
Thank you so much for having me. I really appreciate the time.
Awesome.
Oh, how about the Tenant Safe Harbor Act?
Oh, did you catch that one?
I just see a chat just popped up. Well, what about it? All right, so the Tenant Safe Harbor Act by executive order has been extended through the end of the year as far as the time period covered, but it is an affirmative defense to eviction. So if someone is bringing a non-payment case saying, I want to evict them for non-payment, the tenant can say, wait, this protects me from eviction and I can't be evicted. You can only get a judgment against me. That's how it is. That's how it's designed to act. It's designed to prevent evictions during a health pandemic.
Excellent. All right. Well, it looks like, I'm going to say we had that last one slide in there, but it looks like they're all set. So, okay, Lori, we will let you go, and thank you so much. And for the rest of the attendees, just stay on, and we're going to do our wrap up, and then we will be all set with our training.
Thank you so much for having me. Have a good day.
Thank you. All right. All right, everyone. So I'm just going to pull up our final little summary screen here, and then we will have Sarah Douglas give our closing. So let's pull up.
There it is.
There we go. All right, everyone. So I wanted to say thank you for attending our training. We are going to have we're going to have a brief wrap up given by Sarah Douglas here, but I just wanted to leave this slide for anyone. This is our contact information. Feel free to reach out if you have any lingering questions, and we can help get you in contact. And just to review quickly, everyone who is qualified to receive the NOLO, Sarah's going to cover that. But so my part that I will cover is we have put together a survey that we would like all of you to fill out, and I will be putting the link to that survey in the chat box. You do have to complete the survey to receive the password to access the virtual binder. So what I'll do is I will put the link to that survey in the chat box. We will also be emailing it to you, so if you can't access it from the chat box for some reason, not to worry. Once you complete the survey, you'll be given a password. You can then use that password and you'll go to our Cayuga Community Health Network website. And then under the programs, you will find the landlord and tenant training. And then at the very bottom of the page, you'll find the link for the binder. And I'll also put the direct link in the chat box as well. So again, you have to complete the survey to receive the password. I will put the link there in the chat box, and then you can find the virtual landlord binder at the CayugaCommunityHealthNetwork.org website under the Programs tab in the Tenant and Landlord section. And with that, I will hand it over to Sarah.
Mute. Yeah. Sorry about that. We would just like to thank you all for attending today's webinar with us and sticking with us through our technical difficulties. We apologize. This is the first time we've done this through Zoom, but we appreciate you sticking it out with us. And if you have any other questions, please feel free